Right. Well, thank you all very much for attending today. This is the second seminar of the three-part series that I will be presenting. This follows on from the first seminar, and today we'll be considering how one goes about determining and proving the applicable law in relation to property disputes where that property is located abroad. Hopefully you can see on screen my presentation slides. What I intend to do is, following on from last time where we considered how one determines the court's jurisdiction to hear a case involving property located abroad, today we're looking at what law applies to the substantive dispute. So what I intend to do is to provide a simple understanding of how the question of jurisdiction differs to that of applicable law, because that can confuse practitioners time and again. I'll also provide a tiny reminder from last time, namely in what circumstances the court can hear a claim involving property located abroad, particularly for those who were not able to attend the previous seminar. I'm then going to look into the most common type of case, or at least a case and example, where property may be located abroad involving contracts or contracts for the sale of land. There may be other types of causes of action, for example, involving tort. However, given that the time restraints that we have, it's better just to focus on one particular type of example in order to provide sufficient depth. And then what I'll do is provide or focus on a more bulky section on how one goes about proving foreign law from a practical perspective before ending on some practical tips. Now, this is something I mentioned at the first seminar, but it's worth repeating again, which is the reason we're talking about this topic. Now, if you are practicing real property law, there's a chance that you may be dealing with real property that is located abroad, particularly in situations where a contract is purported to have been entered into, for example, in this country. Whilst it is a slightly niche topic, it is fair to say that such issues can and do crop up. And it's not easy at all to decipher what those rules are. And so that's the reason for this three-part seminar series. Now, I'm not considering the position that would apply in Scotland and Northern Ireland, which has a different set of rules, but countries outside of the United Kingdom altogether. I'm also considering the position that has existed post-Brexit, which has led to the relevant EU legislation or regulations becoming domesticated into English legislation. And it's worth reminding yourself that when we talk about conflict of laws, we are really talking about cases where there is a foreign element involved. So whether that's the contract, whether that's the law that applies to a contract, for example, or for the purposes of this seminar, the subject matter of the dispute is the real property or the rights or title relating to that property being located abroad. So some of you may remember from last time that generally speaking, jurisdiction refers to the court's ability to hear the case in the first place. So it's not necessarily looking at the substantive dispute in question, albeit the court at the relevant initial hearing dealing with jurisdiction will, of course, look into the merits of the substantive dispute to a degree. However, it's looking at whether it can hear the case in the first place. It's the first hurdle to overcome for a judge. As set out on screen, it is on the most part the requirements of jurisdiction are governed by the service requirements of CPR 6. So if you can serve a defendant within the jurisdiction, then the English courts will assume jurisdiction, or you may need to serve outside of the jurisdiction. And some of you who attended my previous seminar remember the four-part test I referred to. So whether or not there's a good arguable case that the claim falls within one of the service out gateways under CPR Practice Direction 6B, whether there's a serious issue to be tried on the merits, whether or not the court is the English courts are the proper place in which to bring the case, i.e. forum conveniens. And then there's an ultimate discretion that the court applies at the end to determine whether or not it should hear the case. However, one must always remember that just because an English court has jurisdiction does not necessarily mean that English law applies to the dispute in question. And that's what we're considering today. A slight recap on jurisdiction involving property located abroad. Whilst I say that the service requirements determine the jurisdiction, you'll remember that there is an additional layer when considering property located abroad. As set out on screen, the general rule is the court has no jurisdiction to entertain proceedings for the determination of the title to or the right to the possession of immovable property situated outside England. That comes from the age-old case of Mozambique. However, this is a specific exclusionary rule, and what has to be shown otherwise is the case has to be principally concerned with the question of title or the right to possession of the property. So if that is not the primary part of your case, but one of several equally important parts of the case, the exclusion rule would appear not to apply. So the other questions have to be merely incidental to the question on the right to title, the right to possession of property for the exclusion rule to apply. And where the outcome of the case depends specifically on those questions of title and rights to possession. You see on screen that there are three certain exceptions, one of which we'll be considering today when considering the applicable law. The first relates to tort and trespass, which spells out quite clearly in Section 30 of the Civil Jurisdictions and Judgments Act that the court may entertain proceedings for trespass to or any other tort affecting immovable property outside England, unless those proceedings are principally concerned with the question of title to the right to possession of that property. The second exception relates to contract and equity. So there has to be some form of personal obligation which it would be unconscionable not to enforce. And in Dicey, Morrison, Collins, the key textbook on conflict of laws, examples are given, for example, involving contracts or fiduciary obligations or cases involving fraud, and give specific examples such as actions by a landlord to recover rent under a lease of a foreign land, cases involving specific performance, or even unjust enrichment claims to recover sums paid for the purchase of immovable property. So that could obviously include damages for breach of contract, for example. And the final point or exception is in relation to administration of estates and trusts. And the basic point there really is if you're dealing with property located in this country, but also abroad as part of an estate or trust, then the courts will be more amenable to consider it altogether if that is the case. So today we're considering the substantive dispute, where a contract deals with property that's located abroad. The most simplest example would be a contract of sale of land, for example. So when considering contracts, the Rome regulation on the law applicable to contractual obligations of 2008, known, as you may be aware, as the Rome 1 regulations, applies in determining the law that applies to contracts that have been concluded. To simplify matters, we are here talking about the Rome 1 regulations following Brexit. So in other words, at the end of the transition period on 31st of December of 2020, the Rome 1 regulations, as they then stood, stopped applying to the UK, except as provided by the UK-EU withdrawal agreement. However, the Rome 1 regulations have been converted into UK law as retained EU law and was amended by UK legislation. You'll find the amendments in the law applicable to contractual obligations and non-contractual obligations amendment UK exit regulations 2019. Not the easiest, the easiest legislation to spell out. And that provides for the continued application of the retained EU law version of Rome 1, which is, for our purposes, known as UK Rome 1, as domestic law to determine the law applicable to contractual obligations. For your purposes, if you go on Westlaw and type in the law applicable to contractual obligations, non-contractual obligations, the retained text is actually on Westlaw in full format. So you don't need to go to the actual regulations 2019 to find the small amendments. You can find the entire retained legislation with those amendments on Westlaw. And in effect, I've had a look at this. There aren't any material changes to the original Rome 1 regulations at all, aside from the fact that where it says, for example, member states, it refers now to I believe the wording uses states in general. So it's not specifically relating to member states within the EU. So here we're concerned with UK Rome 1, as I say, it's not materially different to the original Rome 1 regulations. So when considering contracts relating to real estate located abroad, We're dealing here with, firstly, the UK Rome regulations, which applies in situations involving a conflict of laws to contractual obligations in civil and commercial matters. Now, it's important always to look at the scope of the regulations to see whether or not your case fits within it. For our purposes, we're looking at simple contract for the sale of land, for instance. We're not overcomplicating the matter, but there are certain exclusions set out within Article 1. And they are, for example, obligations that arise out of matrimonial property regimes, and also the constitution of trusts and relationships between settlors, trustees, and beneficiaries. So it's worth bearing that in mind in terms of whether or not your case falls within scope when dealing with a contract regarding an immovable. Once that's determined, you go to Article 3. So this is the first, you take the step at a time, i.e. do you fall within the scope of the regulations. Then you come on to the question of whether or not your contract in fact expresses in some way, shape or form a choice of law. So Article 3 confirms that a contract shall be governed by the law chosen by the parties. This can be expressed or clearly demonstrated by the terms of the contract or circumstances of the case. So in other words, there's a way in which to imply that choice of law based on the surrounding circumstances. In fact, there is a particular report that's worth bearing in mind when interpreting this, interpreting the regulations. This is the Giuliano Lagarde report, and you'll find that online. That report dealt with the previous Rome Convention, but it has been used to help in interpreting the UK or the Rome 1 regulations generally. And in that report, it's stated as an example of applying Article 3 as a contract specifically referring to the property legislation of the lex situs, i.e. where the property is located, the seat of that property. And if the property legislation is referred to within the contract, that might provide a sufficiently clear indication that the parties intended that law to apply. Indeed, the parties can select the law applicable to the whole or part of the contract. It doesn't have to specifically relate to the entirety of that agreement. But in reality, for our purposes, the contract may not specify expressly or impliedly what law is to apply to the contract, in which case you have to go to Article 4, which deals with the question of choice of law, the applicable law in the absence of choice. And so to the extent that the law applicable to the contract has not been chosen, the law governing the contract shall be determined as follows, and this is set out in Article 4. And for our purposes, dealing specifically with property located abroad, that a contract relating to a right in rem in immovable property or to a tenancy of immovable property shall be governed by the law of the country where that property is situated. Generally speaking, a conveyance of land or a transfer of the interest in land is governed generally by the lex situs, i.e. the seat of the land where the land is located. But here we're dealing with a contract, underlying contract relating to the right in rem in immovable property or a tenancy. So, for example, here a contract for the sale of land, and the example given in Diocese Morris Collins is an agreement for a transfer of land or regulating the relationship between the parties to such a transfer, such as a tenancy agreement. So the UK Rome 1 regulations do not deal with property rights, and so they can't extend to the actual transfer of the proprietary interest in land, but it deals with the underlying contract for sale or a tenancy agreement, for example. But if a specifically enforceable contract for the sale of land governed by English law relate to foreign land applies, so there is a contract for sale, a written contract for sale, then that can take form as an equitable conveyance. And you can bring a claim in this country for specific performance on that basis. So what is a right in rem? Well, that's defined in the EU case, I believe the Court of Justice case of Elms Property Services in SP of 2020, where it was stated that a right in rem is a right which has effect against all, rather than only having effect as against a particular person or class of persons. It's worth bearing in mind that for the purpose of interpretation of the UK Rome 1 regulations, you still look at you can still look at the previous case law or previous EU case law from the Court of Justice. In terms of a tenancy, this need not involve a right in rem, but must be directly concerned with the rights and obligations directly arising under the agreement concerned with the use and enjoyment of premises. And that comes from the case of Sanders and Van der Put, again, a 1977 decision from the Court of Justice. However, there is an exception when it comes to tenancies. In the Rome 1 regulation under Article 4, it stated that a tenancy of immovable property concluded for a temporary private use for a period of no more than 6 consecutive months shall be governed by the law of the country where the landlord has his habitual residence, provided that the tenant is a natural person and has his habitual residence in the same country. Dicey makes very clear, based on a very old case or a combination of very old case law, that if there is a possibility of an extension of that 6-month period, that has to be left out of account. So we're talking about that first 6 months. If the tenancy is for private use for a period of no more than 6 consecutive months, then it shall be governed by the law of the country where the landlord has his habitual residence, provided the tenant is a natural person and has his habitual residence in that same country. If that wasn't to apply, then you'd go back to the original rule in respect of tenancies, which would again make very clear that the law governing the contract will be where the property is situated. It's also worth remembering that if there is a break clause within that tenancy agreement, and the tenancy the period within that tenancy agreement is no more than 6 months, that does not bring the tenancy within scope. So then we come on to what is the meaning behind habitual residence. So an adult is, in general, habitually resident in the country in which he or she has established a residence, which is his permanent or habitual center of interest. So in determining what is a permanent or habitual center of interest, the European Court has identified numerous factors. They look at the person's family situation, the reasons for the move, the length of continuity of the residence, stability of employment, person's intention from all the circumstances. So that would help in assisting whether or not that person's permanent or habitual center of interest is located within a certain country. And again, the same would apply to the tenant when considering tenancies where the period is no more than 6 consecutive months. What the court's really looking for is whether or not there is a stability or a stable home for that particular natural person, and whether or not appreciable periods of time has been spent in that country, so a form of settlement has been obtained in that country as well. It's worth also looking at Article 19 of the UK Rome 1 regulations, which also sets out some additional principles to bear in mind when dealing with the concept of a habitual residence. And it makes clear that when dealing with companies and other bodies, then the habitual residence is that of the central administration. So that would most likely be registered office address or the primary business address of a natural person acting in the course of business activities. It's defined in Article 19 being their principal place of business, or where a contract is concluded dealing with a branch, agency, or any other establishment. Is the place where the branch, agency, or other establishment is located shall be treated as the place of habitual residence. And the relevant point in time, which is made clear by Article 19, in determining habitual residence is the time at which the contract was concluded. However, and this is probably the most important point, is that there is an escape clause which allows one to consider whether or not there's a particular other law that should apply to the contract at hand when dealing with property located abroad, or any other absence of choice provisions within Article 4. And that comes from Article 3, which states that where it is clear from all the circumstances of the case that the contract is manifestly more closely connected with the country other than that indicated above, and in when I mean above, it's for our purposes the example involving property located abroad, where we're dealing with rights in rem, and therefore it's the law of the country where the property is located being applicable. Then the law of that other country shall apply. So the focus is upon whether or not there are connecting factors which are manifestly more closely connected with another country. So this might be invoked where, for example, the contract is entirely connected with one country, apart from the simple fact that the land is located in another. However, in Dicey, it does make clear that the location of the property is still a substantial connecting factor, and that strong factors are still needed to displace the general rule. That the law that applies to the contract is the law of the country where the property is situated. However, there are a couple of supporting, I say authorities, but persuasive points that can be raised from one case and also from the Giuliano-Lagarde report. The first comes from Advocate General Bott in a case called Inter Container Inter Frigo, which is again a 2009 European Court of Justice case, where Advocate Bott said as follows. He gave an example of a lease. He stated that it may be assumed that such a contract concluded between two French nationals, the object of which is a seasonal rental in Italy, would have stronger connections with France. In that case, a number of elements converge in a country other than that designated by the presumption. The parties of the contract are both French nationals. The contract was no doubt concluded in France, and it would be in their best interest for French law to be the applicable law to the contract, if only for reasons of language and because that is the law of which they are deemed to have knowledge. That shows an application of their escape clause provision, albeit I believe that might have been in respect of the previous Rome Convention, but nonetheless, it can still apply here. And a similar point was made in the Giuliano-Lagarde report, where it was stated that the presumption could be rebutted if two persons, for example, resident in Belgium, were to make a contract for renting a holiday home in Italy. It might be thought in such a case that the contract was most closely connected with the country of the contracting party's residence, not with Italy. So as you can see, where you deal with a contract for the sale of land, and that's located in, and that contract was made in another country, then arguably speaking, even if the property is located in a country other than where that contract was concluded, one can utilize the escape clause to try and rebut the general rule. Just veering away slightly for a moment and dealing with the question of the transfer of rights to land, the actual conveyance and transfer, or the proprietary interests. The general rule there is slightly different. The general rule there is that all rights over or in relation to land are governed by the law of the country where the land is situated. That doesn't come out of any regulation, but the application of previous common law cases. So again, where the land is located, that's the law that governs the proprietary interest in land. But when I say that, it's not necessarily the domestic law of that country that would apply, but the way in which the courts of the country apply the domestic law, or the decisions of the courts in that country. It's not readily apparent in my mind how that would work, but in Dicey, the example given is that if another country has their own conflict of laws rules, then those would equally be applicable. For our purposes, most likely be simply the domestic law of that country that would apply. And the reason behind that is obvious, that any other rule would be ineffective because at the end of the day, the land can only be dealt with in a manner which the lex situs would allow, where that property is located. The question whether a conveyance of land is formally valid must also be determined in accordance with the lex situs where the property is located, as well as its material or essential validity. So what estate is created, what title that the person who's bought the land, for example, assumes, is determined by the lex situs. Whilst we don't have time today to go through other points that arise from the Rome I regulations, it's worth bearing in mind that what I've talked about today is not the exhaustive principles that come out of UK Rome I. There are other elements to look at in addition. So for example, Article 3.3 talks about laws that can't be derogated from by agreement. So where you do have a choice of law, but the law of the forum where the contract's concluded, for example, has certain laws that can't be derogated from by agreement. That also applies under Article 3.4 when dealing with EU law of the member states. There are also, under Article 9, considerations of the overriding mandatory provisions. So there we're talking about any laws which are crucial for a country to safeguard its public interest, for example. Those would override any applicable law that falls under Rome I regulations. And also Articles 10 and 11 deal with the material validity or the formal validity of contracts. So those are worth bearing in mind, in addition to Article 21 as well, which deals with public policy points. In my mind, it's not readily apparent that those points will be of immediate importance in most cases, and it would be quite rare for the law that applies pursuant to Roman regulations to be overridden by a certain other law. But it's just worth bearing in mind going forwards. But a particular provision to bear in mind is Article 12, which says that the law applicable to a contract by virtue of the UK Roman regulations also governs its interpretation, its performance, breach, assessment of damages, modes of extinguishing obligations, for example, termination or principles of limitation. But the manner of performance and the steps to be taken on defective performance, in determining that, regard has to be had to the law of the country where performance takes place. So again, that supports the point that where you're dealing with a sale of land, foreign land, for example, the performance in actually conveying the property, the actual transfer, the proprietary interest, is that the performance is dealt with by the lex situs, so where the property is located. For our purposes, if we go to the conclusion that foreign law does apply and it's different to English law, well, how does one go about actually proving that foreign law in a case before the courts in England? The critical question is really all about proof of foreign law, and the first question to ask is whether or not you're in fact relying on foreign law in the first place. The first point to note is it is well established that foreign law is a matter of fact. It must therefore be pleaded in your particulars of claim if you are relying on it, in the same way as any other fact. So that's quite different to the normal course of events involving expert evidence, for example, and it can be easily confused and one can easily forego that requirement. But wherever foreign law applies, it must be set out within your particulars of claim. The second question to ask is how you should go about proving that foreign law. It's worth noting that English courts take judicial notice of the law of England, but they don't take judicial notice of the law of a foreign land or foreign law. That comes from the case of Lloyd and Guibert, an age-old English authority of 1865. Therefore, you have to prove foreign law. You can't simply take previous English decisions on that may have ruled on that foreign law before. So there's no real set precedent. And that comes from the case of Lassard Brothers and Co. Midland Bank, a 1933 Court of Appeal decision. Although there is a subtle difference here in that those previous decisions of the English courts may be admissible in evidence for the purpose of proving foreign law. And it's worth going to the Civil Evidence Act 1972, Section 4, for assistance on this. And in Section 4.2, it's stated as follows: that where any question as to the law of any country outside the United Kingdom with respect to any matter has been determined, then in any civil proceedings, as I mentioned below, and I'll come on to which type of civil proceedings apply for our purposes, any finding made or decision given on that question in the first mentioned proceedings shall, if reported or recorded in citable form, be admissible in evidence for the purpose of proving the law of that country. And if so reported or recorded is adduced for that purpose, the law of that country with respect to that matter shall be taken to be in accordance with that finding or decision, unless the contrary is proved. It's worth noting that it's also stated that that latter point shall not apply in the case of a finding or decision which conflicts with another finding or decision on the same question. So if there are conflicting authorities, that may prove problematic. And the types of proceedings for those citable authorities, for our purposes, the only one really is the High Court. So it essentially has to be a High Court authority, or an appeal arising out of any such proceedings, or proceedings before the Judicial Committee of the Privy Council, from any decision of any part outside the United Kingdom. So it could be an appeal authority as well. But it can't be a simple reliance on a previous county court decision, for example. So in reality, the effect of it is, if we are in a county court hearing, most likely you will be facing a case in the High Court involving these matters. But if it is a county court matter, you can't rely on another county court decision, and the usual hierarchy in terms of precedent would apply, albeit it's not a strong precedent because the contrary can be proved. And as I'll come on to, the court still has its own independent judicial thinking involved in determining whether or not to apply it. What this means, in effect, is that it is possible for the English courts to reach different conclusions in different cases as to the effect of a given rule of foreign law, and that the decision about the content of foreign law creates no real precedent. It's merely evidence that can be admissible in assisting you in proving foreign law. Now, there are exceptions where foreign law need not be proved, but albeit these are quite rare, but just worth bearing in mind, where a statute expressly provides that law is a notorious fact, i.e. it's an obvious finding, it's indisputable. If according to English law, the foreign law is the same or substantially similar to English law. And as I said earlier, appeal courts with jurisdiction to determine appeals from courts of several countries, they can take judicial notice of the laws of those countries. So in that case, the Supreme Court or the Privy Council, for instance. Now, foreign law need not be proved if it is admitted. And that comes from the case of Mullis and Owen. I mean, in that case, there was an express admission in the statement of case, but you could also have the usual deemed admission if you fail to deal with a point in a particular of claim, for instance. And also, when dealing with interpretation of foreign statutes, the courts may decide the question of foreign law without proof if requested to do so. Or they may simply take the practical option of determining the question of foreign law without proof. But I suspect that's likely to be rare and quite a risky approach for the court to take, and I don't see a court with confidence taking that approach. It's likely to rely upon some form of expert evidence of foreign law, which I'll come on to. Worth bearing in mind that appeal courts are ready to interfere with findings of fact. It does not appear that appeal courts are ready to interfere with findings of fact related to expert evidence involving foreign law, and any more they are with a normal finding of fact. So the same approach to appeals would apply to findings of fact as they do to foreign law as a finding of fact. So once we've considered that foreign law requires proving, then how do we go about doing this? Well, the simple answer really is expert evidence. Without the assistance of the expert, the court is not really in a position to evaluate or interpret that law, whether that's by way of interpretation of statute, case law, the relationship between the statute and the case law, the way in which the legal system operates in another country, for example. As set out on screen, there's a key authority worth reading in full of Brownlee and FS Cairo, a Supreme Court decision of 2021, where it suggested obiter that the need for expert witness evidence is outdated. It depends on the nature of the issues and of the relevant foreign law. And instead, you can simply produce the text with a translation. That's one of the points that arises from Brownlee. But in my view, that's a very risky approach and not advisable way forwards, unless the case is that simple, which I don't suspect will be when dealing with questions of foreign law. Now, the expert can be a former judge in that foreign jurisdiction, a legal practitioner, a former legal practitioner, or importantly, even an academic who has knowledge of the law. But of course, it will be for you to satisfy yourself using their CVs, that these individuals are both legitimate and experienced enough to be able to produce the expert report. So in the same way as you would go about a Part 35 expert report, you would want to make sure that they are independent and plausible in the normal way. Section 4.1 supports what I've said, where it states that it is declared that in civil proceedings, a person who is suitably qualified to do so on account of his knowledge or experience is competent to give expert evidence as to the law of any country or territory outside the United Kingdom, or of any part of the United Kingdom other than England, Wales, irrespective of whether he has acted or is entitled to act as a legal practitioner there. So it's not necessary to approach a current legal practitioner. It can be an academic or a former legal practitioner or a former judge. But it would be advisable probably to approach a current practitioner to provide expert evidence, just for belts and braces more than anything. A good guide, as I say, is to use Part 35 of the CPR. You should still apply for permission to rely on the expert evidence in the normal way. But having said all of this, does that mean, based on all that I have said, that a court can simply accept the foreign law evidence that's presented, whether it's disputed or not? The answer to that is no. Normally, the court will accept it, one would have thought, but it will not do so where the evidence is, for example, obviously false, lacking in objectivity and impartiality, where the judge considers that the expert didn't apply his mind to the real point of law, or the matter stated by the expert did not support his conclusion by any mode of reasoning, or the expert evidence was little more than an assertion of an opinion unsupported by authority or other evidence. That all comes from case examples from Dicey, Morris and Collins for a variety of, again, age-old case law. In other words, the court is not inhibited from using its own intelligence as to the question of that expert evidence. That comes from the case of A.S. Talina, an Estonian state steamship line, a 1947 Court of Appeal decision. So the court can use its independent modes of thinking. It can challenge that expert evidence. It can reach its own conclusion based on what's being presented by way of the foreign law that's appended most likely to that expert report, if it feels it's necessary to do so. So the court will also look at the meaning of a foreign statute, for instance, if it's inconsistent with the text or the English translation, or it's not justified by any special rules of interpretation. So it's also important now and then to get expert evidence on interpretation itself, of how one interprets a particular foreign legal text, for instance. You can even get an expert to simply inform the court the details behind the construction of foreign documents, and then simply leave the interpretation up to the judge. Albeit it would be ideal to have both some evidence on the application of the law, but also on how it's interpreted, so the court has a full picture. It was stated in the case of Stafford, Allen and Sons and Pacific Steam Navigation Company, a 1956 decision, that where a contract, for example, incorporates foreign statutes as part of its terms, the court's construction is without reference to foreign rules of construction, unless the parties intended it to be construed with reference to the foreign rules. It's worth bearing that in mind. The court should usually defer to the meaning of the expert, as I say, that attaches to a foreign case law, and not conduct its independent research. But the court is not bound to apply the foreign cases if satisfied on the evidence that the decision does not accurately represent foreign law. So going back to what we talked about involving the use of previous decisions, even of this country, to prove foreign law, the court can reach another decision. And that comes from the case of Guarantee Trust Corporation, Hannay, a 1918 decision. The usual mode of proof would be via expert evidence, whether that's expert evidence of the application of foreign law, its interpretation, or otherwise. But are there other modes of proof? Well, as I stated, there is already one in Section 4.2 of the Civil Evidence Act 1972, by use of previous English decisions as citable authority. But that, again, is only prima facie applicable. It can be if the contrary can be proved, then the court can steer or veer against that decision. Or alternatively, you will see that the burden of proving foreign law is always on the party that asserts it. So irrespective of how one goes about proving it, it's worth remembering, if you are asserting the foreign law, whether that's on the basis of a claim or a defense, should do your best to produce the best expert evidence that is available. I wouldn't suggest relying specifically on citable authority alone. Now, you have to go back to the decision of Brownlee and F.S. Caro, which also set out a number of other principles. I've set out on screen what's called the presumption of similarity and also the default rule. And the court has said, in that case, it was Lord Legat's decision, the court said as follows, that there is a default rule that treats English law as applicable in its own right, where foreign law is not pleaded at all. So remember, it's not mandatory to rely on the foreign law. But one would question if that risk is worth undertaking. Ultimately, the court may decide against you. There's inherent uncertainty involved, where there is a foreign element involved in the case. So simply stating, well, let's not plead it and simply see how the English law would apply, whether or not the court will actually do that, is definitely an approach not an advisable way forward, especially when advising clients. It's worth at least checking what the foreign law says about it before making such a decision. And then there is what's called the presumption of similarity, which Lord Legat stated was a presumption that only applies where it is fair and reasonable to make on the facts of the case. And so the presumption of similarity is where foreign law is recognized as applicable, but you've unfortunately not been able to prove it, or there's insufficient evidence to prove it. So the content of the foreign law will be presumed to be the same as English law. And that principle originated from Dynamite AG and Rio Tinto, set out on screen. But Lord Legat made very clear that it's a rebuttable presumption and only applies where it is fair and reasonable to make on the facts of the case. I suspect the likelihood of relying on the presumption of similarity is likely to be low, and it's probably not fair and reasonable to rely on the presumption alone, for the same reason as you wouldn't rely on the general default rule where you haven't pleaded foreign law. But where it would apply is likely to be in cases where you're dealing with another common law system as opposed to a civil law system. Not likely to be applicable where you're dealing with a statute where there's specific legal text. So in my view, it's a very risky approach for practitioners to take, whether to rely on the default rule or the presumption of similarity. So I said on screen that there are four things or there's certain steps to take. Are you relying on foreign law? Have you pleaded it? How are you going to prove that foreign law? And is it worth taking the risk of relying on the default rule or the presumption of similarity? Probably not. And then we end with some practical tips, which really arise from what I have said earlier. But when dealing with conflict of laws generally, and a couple of those practicals actually were relevant for the last seminar, it's easy to get confused. So I said on screen, one, you must make sure you know the difference between jurisdiction and applicable law, and make sure you consider the first question before the second. Whilst I haven't provided a full breakdown, make sure you read UK Rome 1 for yourself. Question whether or not you fall within its scope. Has a law been chosen? If not, do you fall into one of the rules relating to the law in the absence of choice? Then take a judgment call on whether or not to consider the escape clause. Are there substantial connecting factors pointing in the direction of another country other than where the property is located? So where was the contract entered into? Where do the parties reside? Whether the contract relates to other subject matter and performance in another country. Where were the funds paid, for example? And once you've determined those questions, determine what the applicable law is, then consider whether you need to prove foreign law and how you should go about this. So when dealing with questions of rights or title to possession of land, and proprietary interests, that's where it'll be the most important to consider proving foreign law, because that will effectively the manner of performance under that relevant contract. To do that, you must question, who do you instruct? Ideally, a current legal professional would be the way forwards. And you should follow the Part 35 format and get a Part 35 expert report. Make sure you seek permission to rely on expert evidence in the normal way. And then question whether you take advantage of the default rule and presumption of similarity. In most cases, you probably wouldn't want to take that risk unless the case is of its most simplest nature. And then it's important to bear in mind that you understand your case fully. So last time when considering jurisdiction, we said the same thing. Does the case fall within the requirement of dealing principally with the question of title or possession to property, or does it fall within one of the exceptions? Here we're dealing with the enforcement of obligations in your contract, or actually are we dealing with the rights to the property itself? The former is determined by UK Rome 1, and the latter has a general rule of application that you apply the domestic law of the country where the property is located. So those are the key practical tips. Is essentially to take everything a step at a time in order to reach that final conclusion in terms of how you go about proving that foreign law. I've done my best to simplify the Rome 1 regulations where it applies to property located abroad, but it's, again, worth stressing that you read it for yourself, in addition to the Giuliano Lagarda report and some of the authorities that are referred to. So thank you very much for attending. If you have any questions, feel free to ask away using the Q&A function, but I'll stay here for a couple of minutes more. I do have my email address there on screen in bold. Feel free to get in touch with me if you do have any questions that way. And the next seminar, we'll be dealing with the final hurdle, which is the enforcement and recognition of judgments involving property located abroad. And I believe that's in September. So I look forward to speaking to you all then. Thank you.